and your statement of case or statement of facts, and the argument itself. On the statement of case or statement of facts, they differ depending on jurisdiction. Under the federal rules of appellate procedure, the procedural history and the factual history go into one document called a statement of the case. And then the Second Circuit rules say that the procedural history has got to go first. Okay. And so that's what your statement of the case is. What I'm really looking for is your factual history. So if your factual history is in a section called statement of the case, give me your statement of the case. If your factual history is in a section called statement of the facts, give me your statement of facts. So whatever it was called under the jurisdictional rules that you filed your appellate brief, that's what you're gonna do. Okay, so again, the 6 sections: the cover page, the table of contents, the table of authorities, the summary of argument, the statement of the case or statement of the facts, wherever it is that your facts live in your brief, and then the argument section. So you'll be annotating all of those sections. Okay? And it'll become more apparent toward the end of the semester why I'm having you include the cover page and the table of contents. That has to do with formatting that's persuasive, and so that's why I have you include those things. Okay, so those are the sections. So your theory of the case, like I said, that headlines your summary of argument. That's going to be the beginning intro of your summary of argument, and it's sort of the headline for your case. In a single sentence, it should tell your reader what your factual theory is and what your legal theory is. And so I'm going to show you one example of a legal theory, of a theory of the case. That is interesting how that worked. Okay, there are my people. Here we go. Okay, does everybody see this slide?
Yes.
Okay. So this is, of course, a line from Folsom County Prison by Johnny Cash. I shot a man in Reno just to watch him die. This is a theory of the case, okay? Now, it happens not to be a flattering theory of the case for the defendant, but this is a theory of the case. What is the legal theory here? Anybody, what's the legal theory? What is the legal claim here? It's criminal, right? Yeah, Joan?
I shot a man in Reno. He killed somebody.
He killed somebody. What kind of killed somebody, Randy?
Murder.
Murder. What kind of murder, Marilyn?
Intentional?
Yeah, this is intentional premeditated homicide, right? There's your legal theory. You got that. It doesn't say anywhere, I committed intentional premeditated homicide. But you got that, right? Okay. Where do you get that from? If it doesn't say that's the legal theory, how do you know that's the legal theory? Yeah, Nicole Spencer.
Because we know that motive for intentional murder is that someone decided to shoot someone with the intent of killing them.
Well, no, not motive. We don't care why you intentionally killed them, do we?
No.
No, we don't care why. So, what is it that we know, Joan?
You deducted from the sentence.
Okay, how do you deduce that?
You know that he wanted to see somebody die, just to see him die.
Okay.
So you know that there was an intention there.
Why isn't that manslaughter? Randy, why isn't that manslaughter?
I would say because he just wanted to watch him die, so it seems like it was something depraved and it was intentional in terms of the
Okay.
murder.
So now you're looking at the elements of homicide, right? Of first-degree homicide. Depraved indifference. Okay, that's one way you could do it. Or simply intent. You don't have to have indifference. You can have intent. You also do it through process of elimination. You guys clicked through a lot of elements, and what I'm trying to get you to do is slow down so that you can see the elements that you clicked through, okay? So Randy said, okay, well, it does look at least like depraved indifference, probably like intentional homicide. So that's a vote in favor of intentional murder. But then what is it not? What do you know that it's not? What are the other types of homicide? Marilyn?
Well, I was going to say it's not accidental. It's
not accidental, so we can rule that out.
mhm.
What else is it not?
It's not a crime of passion.
Not a crime of passion. So by clicking through the different claims that you know of, you can deduce that this is first-degree murder. So you can, hold on just a second. I'm going to itch my eye a couple of different times, and I know it's kind of weird. I had laser surgery on it Friday, and it's healing, and so it's super itchy. It's driving me nuts. Okay. So, you clicked through those without even realizing you had done it. You clicked through those crimes and said, "Oh, well, this is malice aforethought. That's what this is." Okay. What is the factual theory? Yeah, Ryan, go ahead.
It's exactly what the sentence says. I shot a man in Reno just to watch him die. It's the
Okay.
fact.
From just to watch him die, what do we know about the defendant? What can you deduce about the defendant's character?
He's a murderer.
Well, yeah, he's a murderer. That's more of a legal status. Randy, what can we deduce about him?
Well, number one, it was definitely not defense, and he takes pleasure, or he likes to kill people for no reason.
He took pleasure in it. I shot him just to watch him die. You can deduce that he took some pleasure from it. What else could you deduce? Nikki?
That he doesn't have a good moral character.
Okay, he's not an upstanding citizen, right? We know that he really doesn't feel much remorse, if any remorse. I shot a man in Reno just to watch him die. He utters these words from prison. And so, so far he has yet to come up with any, he's yet to dig deep and find any remorse, if there's any in there. Okay. So I shot a man in Reno just to watch him die. Obviously, the theory of the case doesn't come directly from one of the parties. So if you were going to say, if you were going to use this as a theory of the case, it would be, he shot a man in Reno just to watch him die. What is the impact of taking out the word just? I shot a man in Reno to watch him die. Does it change the meaning any? Ken, what do you think? Why does it change the meaning?
Because just is just showing that he just wanted to see him die, but when you take that out, he could have there could have been another motive for shooting him.
Well, no, it says even without the just, it's I shot a man in Reno to watch him die.
Yeah, but it could be other than watching him die.
Well, no, it says I shot a man to watch him die. That's the reason I did it. I shot a man to watch him die. How is that different than I shot a man in Reno just to watch him die? Nikki?
I feel like it changes the tone of it, and it could be open to a little bit of interpretation.
Okay, in what way?
Well, I shot a man in Reno just to watch him die means well, I take it as that's the only reason why I shot him, because I wanted to see him dead. But I shot a man in Reno to watch him die. To me, I think maybe there's another reason that could be somehow tied to it.
Okay, I think you and Ken are saying the same thing, and you're getting to it. There is a difference between just to watch him die and to watch him die. The addition of the word just does change it, but you guys aren't quite there on what it. You're right that it's about the tone. Marilyn?
Well, I think that just implies that, you know, he's callous. He wanted to actually do it to watch him die. But if you take out just, it could mean that he did kill the person and he watched him die, but that was not his intention.
Okay.
That's what I see.
Okay. Randy?
Well, I was thinking just to me means like to him, it's not a big deal. Because when I use that word in a different sentence, I was just watching TV. I was just hanging out with my friends.
Right.
There's nothing serious about that.
Somebody calls you and says, "What are you doing?" And you say, "I'm watching TV." That sounds like you've interrupted something. Somebody calls you and says, "What are you doing?" And you say, "I'm just watching TV." Sounds like waiting for something better to come along, filling the time, right? So just adds that element of insignificance to it. It's not a good reason, and I know it's not a good reason, and I don't care. You know, it entertained me. It filled the time. So we have now spent 20 minutes. Is that right? No, 15 minutes talking about an 11-word sentence. And there's a lot packed in there. And a good theory of the case has a lot packed in there. To get to this kind of sentence, you know, it's taken a lot of discussion. There are 1, 2, 3, 15, 16. There are 18 of us having this discussion. It's taken 18 people about 15 minutes to figure out why this works, okay? And it does work. It's got the factual theory. It's got the legal theory. And so it's all there. So, oops, hold on. Okay, I guess it's gone. I had a chat message from somebody and it's gone now. A good theory of the case is going to be deceptively simple. It's going to look simple. It's going to be easily understandable, but it's going to have a lot of heft to it, a lot of density to it. And it really requires that you think very carefully about what your legal theory is, what your factual theory is, and the best way to use language clearly and concisely to get there, okay? Okay, so now we've looked at a theory of the case and we've seen what that is, and that's why some of you emailed me your theories of the case over the weekend, and I said, no, we're going to talk about it first. Theory of the case isn't something you just try to, just tap out without talking about it. It's a very sophisticated, it's two things. It's a sophisticated drafting technique, and it's a sophisticated organizational technique. And that gets into kind of what we're going to talk about in a little bit about intelligence in legal writing. That the ability to convey this simply requires a great deal of thought and planning and organization, and it really helps your whole document hang together because it marries the facts and the law together in a way that makes sense, in a way that they feed off each other and make each stronger than the individual section, so that, as we say, the whole of the brief is greater than the sum of its individual parts. Okay, so let's now look at something else. Okay, has everybody got whether you do or you don't, the hurricane lyrics in front of them? We're going to look at Yes, I gave you guys a hurricane lyric. Sorry, I'm getting confused. We're doing persuasion in judicial writing this week. And so now I'm super confused about who's doing what. Because they're doing some stuff this week that you guys aren't doing for a while. Okay. So hold on, let me find my hurricane lyrics. So Bob Dylan has 2 songs that are about criminal cases. And one is The Lonesome Death of Hattie Carroll, which we do in Legal Process 2. And then the other one is Hurricane. Hurricane is significantly longer and a little bit more complex than The Lonesome Death of Hattie Carroll. So as you read through it, this is this 2.5, 3 pages is the whole of the argument, both the facts and the law. It's not as tightly held together as Lonesome Death of Hattie Carroll. That one really uses an economy of thought that this one doesn't as much. But nonetheless, this is 3 pages of an entire argument along with the facts. And so one of the reasons I like to use songwriting techniques as a way to talk about theory of the case in particular is so that you can see that you can tell a very full, complete story as long as you're as long as you know exactly what it is you're trying to convey, and as long as you use the language carefully to convey it. And that's something that both poetry and songwriting do very, very well. And so poetry and songwriting are both incredibly useful fields of study for lawyers. And in fact, a friend of mine, Ben Opapari, has a Facebook page, account, whatever, called Songwriters on Process. And Ben actually teaches legal writing in-house at a law firm. But he talks to songwriters. That's what the Facebook page is about. He talks to songwriters about their process of writing songs so that he can use that information to help the lawyers in his firm become better legal writers. And so it's Songwriters on Process. I encourage you, if you're on Facebook, to like that page so you can see some of the stuff he has, or you can just Google Songwriters on Process, Ben Opapari, Opipari. And it's great stuff. Songwriting is such a great thing for lawyers to study. And again, poetry too, if you have any interest in poetry. I had no interest in poetry. I took a class on poetry in college, and I started to become impressed then with how hard it is to write good poetry, because it's all about concise use of the language. And so if you want to become better at theory of the case, the strategies that poets and songwriters use are really incredible for that. I could do a whole course on just songwriting, poetry, and theory of the case. Okay, so you've got the lyrics to Hurricane. So what is the factual theory? In one sentence, how would Bob Dylan summarize these facts? Yeah, Stan.
Well, in the lyrics, the song goes, "Here's the story of the hurricane, the man the authorities came to blame." The second sentence, I think, would be Bob Dylan's theory of the case.
Wait, okay, so you'd say the second theory is the full theory of the case?
Yeah, the man.
Yeah. Here comes the story of the hurricane, the man the authorities came to blame. But what is the factual theory?
Well,
you've got the whole thing together, but let's pick it apart. What is the factual part? Yeah, Nikki?
I don't know if this is right, but racial profiling leads to false conviction.
Your factual theory generally is going to be something more specific to the people. You're right that it's about racial profiling, but racial profiling is closer to a legal theory than it is to a factual theory. So what is it about the people? What is the factual hook that we can use here? Either the circumstance that Reuben Carter finds himself in, or the motivation of the officials, or the kind of people that the officials are. Loretta?
I think it's that Reuben Carter was framed.
That's a legal theory.
Oh, it is. Okay.
Yeah. You son.
I think, I'm not sure if I am on the right track, but what I'm thinking is that Carter was forcibly tried and convicted.
Yeah, again, that's kind of more towards the legal theory. I'll tell you what, let's start with the legal theory. Or wait, let me get Lorraine and Nikki back in here, and then we'll move on. Lorraine, what do you think?
I think it might be an innocent black man used as a scapegoat again for a white murder. I don't know. I know that murder I'm trying not to put murder in there. An innocent black man used as a scapegoat in a white, I don't know.
Yeah, so something about Reuben Carter being a scapegoat, right?
Yeah.
And then what's the other side of it? What about the police? And the DA also. What do we know about them from the lyrics? Nikki, what do you think?
They were like corrupt. I don't know how. Because there are lines in there. It says, where did I just see it? No one doubted that he pulled the trigger. So I mean, they're just saying that he did because he wasn't a good guy, at least, or somewhere in there it said that.
Okay, Loretta?
I think it's that the authorities pushed those robbers to falsely accuse him and testify against him. They initiated all that. They made that happen.
Right. So you're saying you agree with Nikki that the authorities were corrupt.
Yes.
Okay, Lorraine?
I see why you changed it to Reuben Carter instead of an innocent black man. I think because he has a history. So knowing that he has a history, they just found someone to blame it on. Or they wanted to blame it on somebody else other than this man.
Yeah, and here's something interesting, this whole thing about, Reuben Carter, because Reuben Carter was a boxer, who's a very famous boxer. Reuben Carter likely would have been remembered as far more famous had this not happened. And so what's interesting, have you guys seen the thing running around Facebook? There's the kid at, I think it's Stanford, who, the young man who raped a woman at a party, and he was an Olympic swimmer, and he was favored to go to the Olympics at some point, and he had raped this woman, and there were a couple of things that happened that were noteworthy, that she pointed out in her victim impact statement, and that commentators have pointed out. One is that there's no mugshot of him circulating on the internet. No mugshot circulating on the internet. And this gets to, there's a difference between, there are studies that show that, media studies that show that when black defendant pictures are displayed in the media, the mugshot tends to be displayed. When white defendants are shown in the media, a school photo or some sort of family photo tends to be displayed. And so you could say an innocent black man, but the problem is, as a society, we don't believe much in the innocent black man. That is not a stereotype that we have. And so innocent black man doesn't help you here, right? But Reuben Carter does. One of the things they've made big hay out of with this with this convicted rapist at Stanford is that, you know, he was a swimmer, he had a future and things like that. So when you use the name Rubin Carter, instead of describing him, you invoke everything that Rubin Carter is. You know, he was a champion, he was a boxer, he was an athlete. He was, you know, by all accounts, a really good guy. So it matters. Even those, whether you call him an innocent black man, an innocent man, Rubin Carter, a boxer, those things matter. Those things really do matter. And then with regard to the authorities being corrupt, that's his theory here. He presents all of these facts to back that up. That the overall motivation of the government here was not in good faith. Rand?
So I just wanted to say, on top of everything else, was the trial was a pig circus. He never had a chance. I felt like that was kind of a key phrase that kind of led on to what everybody else said, that, you know, he obviously wasn't gonna have a chance. And I guess they used pig for considering most pigs are pink or lighter color, and you don't typically see black pigs, so maybe that was a specifically used word. So but
I don't know. Do you guys, like, I have a couple of theories about pig circus. I think the color one is an interesting theory. I know pig as a slur for police, maybe one. And also the other thing I thought of was there are no pigs in a circus. And so maybe by saying pig circus, what he's saying is, this was an improper way to conduct this proceeding. It would be like having a pig in a circus. Mm-hmm. What's interesting about this, and we'll talk about metaphor later, and I'm going to make a note right now for us to, wait, here it is. I'll make a note right now for us to come back to the pig circus when we talk about metaphor. But what's interesting about metaphor, which is very difficult to create well, hold on. Okay, so what's interesting about metaphor is that it's very difficult to create a good metaphor because the metaphor has to work such that no matter how it's interpreted, it still works. And so the thing with pig circus is that, like, there are several different ways you could interpret that, but they all work. No matter which one you come up with, they all work. Anyway, this is why I love songwriting so much, because it lets us delve into this very deeply with a very short piece of prose. Okay, what is the legal theory? What is Dylan's view of the legal problem? Yeah, Rand?
I think it's easily summarized in the next lyric. Rubin Carter was falsely tried. The crime was murder one. And then it went on to say, guess who testified and the people that falsely lied. So I feel like that kind of surmised all of that in the legal theory. And,
okay. So what claim is that?
That
what are we going to call that?
Premeditated murder that he's falsely accused for?
Well, okay. So what do we, Marilyn, what do we call that? What is that legal theory?
A man was framed for a murder he didn't commit.
Okay, what's the legal theory?
Who
do we hold accountable for that?
For what?
Who do we hold accountable for framing someone?
Oh, okay, the corrupt legal system. Or
you can't sue the legal system. Ken?
I was going to say, like, he was deprived of his, like, civil liberties, and while he was put in jail because he was falsely accused.
Okay, so you could say that this is a 1983 civil rights action. That's one possibility. Dominic? Dominic, you're muted. And not moving. His video may have stopped. Loretta?
I think it said he believes that his country doesn't value justice very much.
So who do we sue for that? It's not a legal theory unless we can sue someone or prosecute someone. It's funny because when I asked you guys for factual theories, you started off giving me legal theories. And now that I'm asking you for legal theories, you're starting off giving me factual theories. It's hard. It's hard to pull those apart sometimes, especially when you're going to put them back together. Rayanne.
If the witnesses committed perjury and the prosecuting attorney knew that, couldn't he go after the state?
For what?
For putting a witness on the stand that he knew was going to falsely testify?
Who in the state?
If the prosecutor knew that the witnesses were going to falsely testify.
There we go. Prosecutorial misconduct. Okay. So you guys were getting to it. You know, that we've got a corrupt system. We've got corrupt prosecutors. They are acting in bad faith. That's the factual theory. But then the legal theory that goes with prosecutors acting in bad faith is prosecutorial misconduct. That's the claim that comes out of that. And that's basically what he is alleging. So that's our factual theory, is that it's going to be some combination or a part of Reuben Carter being a scapegoat and the authorities acting in bad faith, being corrupt, and then the legal theory being either some sort of prosecutorial misconduct or a civil rights violation. So Stan had suggested to us that the theory of the case, which embodies both of those, can be found in lines 5 and 6 of the first stanza. Here comes the story of the hurricane, the man the authorities came to blame. What do you guys think of that? What do you get from here comes the story? Loretta?
Is that the factual theory?
Well, no, we've already got our factual theory. Our factual theory is that Reuben Carter is a scapegoat and the authorities acted in bad faith. The question now is, are those two lines a good representation of both our factual and legal theories so that they comprise a good statement of a good theory of the case? Ken?
Well, like, here comes the story. I just think like someone's trying to tell his story and he doesn't have like a voice to voice it out himself. So Bob Dylan's doing that for him by saying, here's the story of the hurricane. And I thought the use of the hurricane was good because you don't know, anything of any demographic about him, a man, whether he's black or white or anything like that.
Okay. Although the hurricane, like at the time the song was written, people knew who the hurricane was. His nickname was Hurricane Carter. So Hurricane, like the conversation that, the comments that Lorraine just made a few minutes ago, Hurricane sidesteps the issue of how to describe him and uses a name of his that invokes his boxing career and his success. And so by using the hurricane as the way to identify him, we're saying, hey, this isn't just some random guy. This is Hurricane Carter. This happened to a famous boxer. Randy?
I would say it definitely embodies theory of the case. I would take it one step further and add the next line, which says for something that he never done. I think that puts everything. I think it wraps it up in like a perfect bow, because
Okay.
you know, if the authorities are blaming you.
Mhm.
And it says for something that you've never done, you could automatically think of some type of corruption.
Okay. Nikki?
I pretty much agree with what everyone said, and I think that it's a good sort of like roadmap to where it's going, because it's pretty much just saying exactly in one precise sentence what's going on. And I could be overthinking this a little bit, but even though hurricane is specific to this boxer, it also could be like ambiguous, I feel like, a little bit with the meaning of the hurricane, sort of just like, I don't know, like a shitstorm is coming and this guy is going to be blamed for something he didn't do. I don't know.
Oh, that's good. Yeah, that imagery of the hurricane. Do any of you guys watch House of Cards? I don't know if it's I can't remember if it's the last episode or the second to the last episode of the current season. They have basically a data miner, a guy who can mine people's search data to come up with a picture of what the campaigners should target, right? And he's using that data to advise the president who's running for re-election, to advise him on what to say and how to phrase things so that certain key words get said together, and that then they can see through the data mining how those key words are playing with people. And so one that was really interesting was, I can't remember the whole context, but they got him to use the word, by the way the president said something, they got the opponent to use the word pretty, something like the issue isn't pretty, and something about like boys going to war. And so the data miner said that was perfect. He did exactly what we wanted him to do. He used the word pretty and boy in the same sentence. And what's going to stick with people is pretty boy. And so the use of language can really be that calculated. You know, the specific words that get used create an impression, and there's nuance to language. And a little bit later in the semester, I'm going to give you guys some resources that you can begin to sort of incorporate into, you know, websites or blogs that you check on a regular basis, that will start to help you refine your sense of the language. So here comes the story of the hurricane. Okay, so here, the man the authorities came to blame. What's the difference between the man the authorities indicted and the man the authorities blamed? Nicole?
It kind of shows that when the investigation started, they weren't necessarily looking at him, and maybe even at trial, they didn't have strong evidence that he committed the crime, but they came to a decision to blame him for that crime.
Well, but why not use the word indict then? Indict says it's a legal term, it's stronger. Indict tells us that they got past the grand jury.
Indict to me feels a little bit more cold. Came to blame kind of shows.
Not came to blame, that wasn't my question. My question is, what is the difference between the man the authorities indicted and the man the authorities blamed? We'll get to came to in a minute.
Indicted seems more procedural.
Okay, indicted is more procedural. Indicted also, like you said, it seems more distant because we've got the grand jury as a layer between the prosecutor and the defendant. Dominic?
Blame shows that it's not that there's compassion, but that it's showing that there's emotion in it. And when you say indict, it's very like Nicole said it's very cold and it's very straightforward. When you say someone blamed you for something, you kind of feel sorry for them because there's a wrong being committed against them that should have never been in the first place.
Yeah, blame has the connotation that indict does not, of being wrongfully accused. When we say I was blamed for something, the suggestion is, without saying it, that was incorrect, that you are not responsible for that, and that you're being held accountable for something that you did not do. And so blame is a really calculated word that conveys something different than indict or accused or any of those things. What about, okay, so now what's the difference between the man the authorities came to blame and the man the authorities blamed? What's the difference between those two? Marilyn?
I think Nicole was getting to it. Like initially they didn't think he did it, but when they couldn't find anyone else, they went there. They decided to pin the whole thing on him.
Right, exactly. And you're absolutely right. Nicole really nailed that the blame was incorrect, but it wasn't a mistake. It was a calculated decision. They came to blame him. They made a decision to blame him. So that carries with it our legal theory, which was wrongful conviction, prosecutorial misconduct, civil rights action. So again, we have a very short statement, those 2 lines. And the reason I don't say those 3 lines, Randy, is because the shorter your theory of the case is, the better. And so where it says for something that he never done, that is implied by the word blame. And so we can have that whole theory of the case wrapped up in 2 lines rather than 3 and still convey all the same meaning. So again, we have a very short statement that really pulls the whole case together. It embodies the legal claim. It embodies the factual claim. So what we've done is we've taken theories of the case that were already drafted and we've reverse engineered them. We've looked at them and said, okay, here's the theory of the case. So from the theory of the case, can we tell what the legal theory was? Can we tell what the factual theory is? And do they hang together in a way that makes sense? So now what we're going to do is reverse the process again and do it in a straightforward fashion, where for your appellate brief, you are going to draft a theory of the case. And to be fair, I want to make sure that there's fair warning and transparency. Ryan and Nikki, they're the only ones. Ryan and Nikki have done this exercise for this brief, I think. I don't think we did it on the trial brief. Have done this exercise. They had to write a 6-word theory of the case. I want to be very clear that does not give them an advantage, and I think that it might give them a little comfort because they know the struggle that's ahead. But it doesn't really give them any. It doesn't give them any sort of leverage or benefit because at the point they did it, it was just it was within the first year. And so what I would expect them to draft now would be much more nuanced and sophisticated. And in fact, I would expect you guys, and I know this will be the case, you guys are going to draft something far more sophisticated and nuanced than I would see out of first years, because first years are still trying to just come to the concept of the difference between facts and law at that point. So you are going to draft a 10-word theory of the case. So that's going to be due at the beginning of class on Wednesday via Twin. There's a folder that you can upload it into. Please don't write it. There's like a note section or a submission section where you can just type it in without uploading a document. If you would, just upload a document, because then I can download them all into a single batch, and that makes it much easier for me to get them and to review them. Okay, and then on Wednesday, when we meet back, we're going to talk about that exercise 8.8, and we'll talk about this a little bit more tonight, right before we finish. We're going to talk about exercise 8.8 on Wednesday, and we're going to use your theories of the case to sort of frame the whole thing, because you're going to be looking at a section of your brief. Okay, so that's theory of the case. Are there any questions before we move on? Okay, fantastic. So now we're going to move on to ethos in legal writing. And remember that the final project is to take the appellate brief that you drafted and to revise it to make it a more persuasive document. And so every class we're going to get techniques, and you've already gotten some techniques with the theory of the case and thinking about authorship and audience last time. Those are sort of broad stroke things. Now we're going to get down for the really the whole rest of the semester. Every class will be an opportunity for us to talk about specific techniques. And so make sure that as you take notes, as you do your reading, as you do the exercises, and the exercises I won't ever take up. You just need to be prepared to discuss them. And the easiest way to do that is to write them out. So every class will introduce you to and will discuss different techniques that you can use in your brief. I don't expect that you'll use every single technique in your brief, but I do expect that you will address the technique either as something that you did use or explain why you didn't use it. Explain why, you know, I could have used significant moment, which is something we'll talk about in several classes from now. I could have used significant moment in the statement of facts, and here's why I chose not to do that. Here's why I think that based on my facts, this is really not, wouldn't have been an effective technique. So I want to see through your annotations that you understand each of the techniques we talk about, that you understand authorship, you understand audience, you understand theory of the case, and now tonight we're going to talk about ethos. Okay, so there are three components of ethos, of course. What are they? Loretta? Oh, you got to unmute.
Intelligence, character, and goodwill.
Yeah, intelligence, character, and goodwill. So somebody tell us, let's start with intelligence. What are the traits of intelligence? What are the characteristics of an intelligent writer or an intelligent document? Nikki?
There's a bunch. It's being informed, adept at legal research, organized, being analytical, deliberate, empathetic towards the audience that's reading it, practical, articulate, eloquent, detail-oriented, and innovative, which was kind of like up in the air a little bit.
So it was what?
It was a little hard to like figure out what that meant in terms of being an intelligent writer. At least for me, when I was reading through the book, they kind of left it up to you a little bit to determine.
Yeah, it is a little bit up to you. Okay. Innovative has to do with using accepted approaches in a new way, maybe coming at the law from a different perspective. Certainly, go ahead.
Would it be something that's like atypical than what, and like maybe your regular person wouldn't go this route, but it's, you know, sort of just like being an innovative thinker, sort of like you.
Yeah, and let me give you an example of an innovation that's making its way into briefs. Submitting color briefs. That's an innovation. Using photographs within the text of a brief. Using a chart within a brief to help make an issue clearer. Those are all innovations that lawyers have begun to use a little bit in the past 5 to 10 years, and that they're experimenting with. So, for example, you know, the rules of appellate procedure and the rules of civil procedure and criminal procedure really contemplate documents drafted on a typewriter. And so if you produce them exactly the way they're supposed to be produced, what you're going to get is something that could have been produced, with a sophisticated typewriter in the 80s. And certainly there's nothing that requires anything more sophisticated than the first one or two versions of Microsoft Word or WordPerfect. And so we're creating documents that looked exactly like the documents we created 30 years ago. And so innovation would be taking a step back and saying, okay, look, here's what the documents had to look like because of technology restrictions, but we don't have those technology restrictions anymore. So what can we do now? What can we do with just a desktop computer and an attached printer that would still fit within the rules, but be more persuasive, would be more evocative, more explanatory? I worked with a guy in Lubbock. I practiced criminal law there, and I didn't do a ton of civil law. I did a little bit of matrimonial. And I was going in front of this one judge. I'd never been in front of him before. And so I went to the guy in my firm who was in front of that judge the most often. And I said, he's asked us to file briefs. Do you have any suggestions? And he said, yeah, write the brief, but it doesn't matter what's in it. He's not going to read it. He said, make a chart. The very end, he said, the very last page of your document needs to be a chart. And tell it, like in the very beginning, in the introduction part, make sure that you have either the first sentence or the last sentence so he catches it. The arguments are summarized in the attached chart. And so this is something that this attorney had started doing because he noticed that the judge never read his briefs. He'd write the briefs, he'd go in, and the judge would say, okay, everybody, I haven't read these briefs. What's your argument? And so he thought, well, let me try to give him something that he could just glance at and have an idea. And he was very successful with that. The judge liked the charts. The judge praised the charts. And so that was an innovation where the lawyer looked at the situation he was in. It was like, there's nothing that keeps me from putting some sort of, synthesis chart or explanatory chart with my brief. And so the judge was always at least somewhat versed in his arguments before they had the hearing. And that always gave him an advantage. And so the other attorney was always playing defense, but what about this argument? Because he could just look down at the chart and know what the arguments were right there. So that kind of thing is an innovation too. Okay. So yes, those are the traits of intelligence. Somebody tell us, what are the traits of character? Loretta?
Truthfulness, candor, zeal, respect, and professionalism.
Absolutely. And then finally, what is goodwill? That one's kind of like innovation. It's a little bit squishy. What is goodwill? Marilyn?
How the lawyer feels about the other side, or anyone who's going to be affected by their argument.
Okay, yeah, that's a good way to put it. Loretta?
That's kind of what I was going to say. It's what his disposition would be towards the audience and the adversary.
Yeah, it has to do with attitude, really. Are you approaching this with a desire to simply do your best for your client and to help the judge to the best of your ability in making a decision? Do you regard your adversary as someone who is honorable and deserving of respect? That's goodwill. And you see goodwill evinced in a lot of different ways. And this is why you don't want to get snarky with the opposing party. This is why you don't want to put those zingers in your brief, because it really undercuts your ethos when you demonstrate a lack of goodwill, when you demonstrate that you think the judge is stupid, or you think the opposing attorney is evil. And so to some extent, you know, the best lawyers are really the ones who think the best of everyone. And that's not easy. That's really not easy to do, to always give people the benefit of the doubt, to think the best of people, to always behave in a way that is honorable and that assumes the best in everyone and yourself. Now, certainly goodwill does not require that you be a chump. There are procedures in the law and in the profession for dealing with someone who does not behave professionally. And there's no reason you shouldn't avail yourself of those things. There are motions for sanctions. But goodwill means you call a lawyer first and say, hey, I noticed you didn't respond to these 2 questions. I assume that was an oversight. Give them the benefit of the doubt. I assume that was an oversight. Could we get some answers to those questions? And then, you know, if they say, oh, sure. I've always said that one of the best things you can do as a lawyer for the opposing party is to give somebody a way to save face. Let them know that, you know, I didn't want to have to file a motion or go to the judge, so I'm going to give you a chance. I'm going to give you an out. I assumed this was an oversight, and I didn't just want to rush to the judge. I thought we could keep the judge out of this. So now they know you're prepared to go if you need to, but that's not your first inclination, and that you'd prefer to just handle it yourself. Those kinds of things go a long way. And the court always finds out about them later, because if you do end up in front of the court later, the first question is going to be, what did you do? What did you 2 do to resolve this between yourselves? And if you can say, not in an angry way, but if you can say, well, Your Honor, I called him on this date. I followed up with a letter. I followed up again. I sent him a copy of the motion for sanctions and let him know that I would give him 10 days and then I would file it. Then I filed the motion, you know. So if you can let the judge know you've taken those actions. Okay. So we've talked about the 3 traits of ethos, or the 3 characteristics of ethos, and then the traits of each one. So what does priming, that article on the science of persuasion, what does priming have to do with ethos? You guys had to be curious. Well, let's back up a step. What is priming? Yeah, Marilyn.
Okay, from what I understand, it's using a question that's not critical first, and then using a second question that is critical, that you want them to respond a certain way to prepare. So you're using the first question to prepare for the second response.
That's a type of priming. What kind of priming? Well, it depends on the order of the question, so I want to see that. Randy.
Well, I was thinking something along the lines of what was said earlier. Priming is when the first question is directly asked in order to get a predisposed answer that you want based on the second question.
Okay. And so what are the 2 types of priming that you read about? Yeah, Randy?
I think the first one that I recall was, and I know I do it sometimes myself when I'm dealing with friends or at work, you would ask for a small favor in hopes that since the small favor is going to be an affirmative yes, you're setting them up for the bigger favor that you really want.
And what's that called?
I think that's called small door or door. I don't remember.
Anybody, what's that one? What's that one where you ask the yes question? Yeah, Ryan?
Foot in the door.
Yeah, that's foot in the door. Let me just wedge in here a little bit. Let me ask you the question that's going to be the easy yes. And then once you're feeling yesly, then you go in for a bigger question and sort of build up to it. What is the other type of priming that you guys read about? Yeah, Ryan?
It's door in the face, where you're beginning a persuasive message with more contentious proposition, and the reader's likely going to reject it, so then they're going to accept later arguments.
Yeah, it plays on the basic notion of human nature that we don't like to say no. And so having said no to something, we're more likely to say yes to something else. And so basically what both of these mean is you use one question as your throwaway, or one issue rather, one legal issue as your throwaway, and then your second one. Yeah, Ryan?
That kind of reminds me, I took negotiation with Abrams.
Uh-huh.
And he always said that when you're negotiating, kind of have like these things that you really don't care about as gimmies and like use it as concessions, so then you can get your other arguments later.
Yeah.
That reminded me of this.
Yeah, absolutely. And actually, my favorite, what this always brings to mind for me, and I'll offer you this because it's a vivid example, so it might stick with you. There's that scene in Steel Magnolias where Olympia Dukakis is describing this conversation that her nephew had with his parents, in which he went to his parents and he said, he's a young man in his 20s, and he said, hey guys, I'm dying of cancer. And they oh my God, that's horrible, that's terrible. And then he says, I'm joking, I'm only gay. And so that's a door in the face. That's a big one. And then the next one doesn't seem so bad. So that's an example of door. And then the foot in the door, again, like exactly what Randy said, you give the little yes so that you can prime them to sort of go along with things. And it's funny because that foot in the door is really one of the principles that cross-examination works on, that you get people into a rhythm of saying yes, 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 yes on your yes, no questions, and then start moving them into things that are harder to say yes to, but they've boxed themselves in on the prior yeses. And so, foot in the door can be a very effective technique. But the idea, whether it's foot in the door or door in the face, what do they both have in common? Yeah, Loretta?
Trying to persuade the person to do or say what you want them to say.
Well, yeah, they are both, but maybe a little bit more specific than that. Jackie?
I feel like it kind of goes more towards the psychological. So you're either giving someone the ability to say no, so that way they in their head feel better about the choice that they make, or getting them in that rhythm so they feel good and they're already on that path. So you're making them feel good about the decision they made rather than the argument itself, I feel like.
Yeah, Nikki?
Yeah, I was pretty much going to say the same thing, where it's almost like in a sense, one is buffing the question to get the result that you want, or the door in the face is, giving them something that they would freak out about. And then it's like, oh no, I just want this. So it's just kind of like easing the blow to get the answer or the result that you want out of the person.
Yeah. Nick?
I almost thought that it's almost like you're sacrificing one of your approaches or one of your arguments just to get, I think for both of them, just to get what you want.
Yeah, absolutely. And so what they both have in common is that the first question doesn't matter. Okay? So if the first question doesn't matter under either one, how do you choose between the two? Ryan?
I think it honestly depends on what kind of person you are and how you want to evoke a response out of someone, because a lot of people don't want to make, maybe like as you said, do say they have cancer and then say, oh well, I'm only gay. They might not want to evoke that type of emotion or say like a huge white lie to get to the truth. And then there's other people who just, they don't really, I mean, for me, I think it's based on the person and what you're most comfortable getting out of the person without trying to feel uncomfortable.
Well, which person? Is this an audience consideration or an authorship consideration?
I think it's an authorship. I can see how it could be an audience, but I think it goes to authorship.
Okay. Nicole?
I think it's more of an audience thing. Depending on the court that you're before, the judge that you're before, you may respond more positively to a foot in the door rather than a door in the face. So you kind of just have to assess the judge and also the issue. For example, and which side of it you're on. For example, if you're representing a guilty party and it's pretty evident that your client is guilty, it may be better to start off with a door in the face than a foot in the door because you know that there isn't necessarily a positive way that you can spin that.
Okay, yeah. So sometimes you're constrained by the issues you have available to you that you may not have anything to get your foot in the door with. So that may be difficult to do. So I also agree. I agree with both you and Rayanne. I think it is both an audience and an authorship concern because it has to do both with what you think your audience will respond to best, as well as what you're most comfortable executing. Because if you're not comfortable with it, it's not going to be persuasive because persuasion is about selling an argument. And if you can't sell the argument, it's not going to matter who your audience is. You're going to falter before you even get out of the gate. So you got to think about who your audience is, whether it's a jury, and that's what jury selection is all about. It's about trying to craft my audience. I'm trying to handpick the audience that I think is going to be most receptive to my best arguments. And if I'm not able to craft the audience that way, if I end up with a jury that doesn't look like the jury that I want, I may need to change my approach because I've got a different audience than I had hoped for. With judges, I'll give you an example. I had a friend who was involved in a custody dispute. And as a requirement for the trial, they had to meet with a magistrate to have a settlement conference. And the magistrate was somebody, as soon as they walked into the magistrate's conference, the lawyer said, "Oh my God, we got it. This is great. This is great. This judge is really well primed." And I'll give you the basic facts were that the dad was suing for custody. The mom was a pretty school teacher, taught kindergarten. She was pretty, she was demure, she seemed sweet, she was articulate, she had a master's degree in early childhood education, and the child was a 9-year-old boy. The dad ran a cigar store, had no formal training in child care, was a dad instead of a mom, had moved relatively far away, a few hours after the divorce. And so the dad was really fighting an uphill battle. And the things that they were alleging the mom had done were really hard to say. It was really hard to imagine this pretty educated school teacher doing the things that they alleged she had done. But their factual theory was she's an alcoholic. And once you factor in alcoholism, then her behavior became easier to understand. So they went into the magistrate. The magistrate was someone known to the lawyer to have a son with a chronic addiction problem. And the judge was actively involved in the county's drug courts and drug rehabilitation programs. So they weren't going to have to educate this judge about alcoholism and addiction and manipulation. Sewn up. So they went into the magistrate's hearing. The magistrate was very favorable to the father, admonished the mother quite a bit, was very hard on the mother. And so that was the judge they were supposed to have for trial. They go in the day of trial about a month later, completely different judge. Completely different judge. And so, like, the whole strategy, it was really an audience-based strategy. The whole strategy sort of went out the window. And suddenly they went from having an addiction-focused, sort of savvy judge on an issue that was important to their case to a judge with a history of awarding custody to mothers pretty much across the board. And so the technique that you use, you've got to consider the audience, but you've also got to consider authorship. You know, what do you have to use? What do you have to sell? So we've talked about the different techniques and sort of the risk that you can't predict your audience may shift, as with a jury where, you know, voir dire can be unpredictable and can give you results you don't want, or a judge switch at the last minute, something like that. Or maybe you think you're going to get one panel on appeal and you get another panel on appeal. So that's one of the risks once you've chosen your approach, because you don't know if that's ultimately going to be your audience, and the audience is very important for priming. So now that we've talked about this, so priming, when they say ask one question first and the other question next, what they're talking about is sort of the organization of issues. So what does this have to do? I'll go back to my first question. So what does this have to do with ethos? We talked about 3 characteristics: intelligence, character, and goodwill. And we talked about specific traits of each one of those. What does priming target? Priming is a technique that evokes which of these traits? Yeah, Nick?
I think it goes with your character the most, because if you can prime somebody to, like you said, like with the teacher, you can set all that stuff up and be like, oh, but she's also a drinker. Like it changes her whole character. Like people kind of throw out the whole teacher and they kind of just look at, like, they think of her in a bar getting drunk.
Well, but that has to do with the character of the people. We're talking about the character of the person arguing. How does priming as a strategy enhance one of these traits that we've identified? Marilyn? But you're right. You're absolutely right, Nick. Marilyn?
I think it has to do with intelligence, specifically the organizational part of the list of characteristics of an intelligent lawyer or an intelligent persuader.
Yeah, I think I think absolutely it goes to whether you are organized, whether you can organize around not just the substance of the issue, but also your persuasive strategy. Jackie.
I was going to say the same thing with intelligence, in the way that it kind of shows when you realize the manner in which someone's presenting their argument, you can kind of tell when someone knows the strengths and weaknesses of their argument and how they present it. So it can be more persuasive to the people who are on the fence, and a smart, persuasive writer would know that and know which points to put where.
Okay. Yeah, it tells the audience that the author has really thought about this, that the author knows the case backwards and forwards and knows, like you said, where the strengths and weaknesses are. Nikki?
Just to add a little bit more, I forgot who said it, but I think that the organization is a key factor in it. And with every step or question or whatever, the person that's on the receiving end is going to be able to establish whether the person asking the questions is trustworthy. And it's sort of like by the end of the series, they should be able to see the big picture of what they were trying to do.
Rayanne?
I may be wrong, but what I also kind of think it goes a little bit towards goodwill, because what I read was that goodwill goes to the advocate's disposition towards a specific audience or adversary, and I think that kind of goes to the organization that the person has when they're going, and the strategy they have when going in front of a specific audience and in front of a specific adversary. If you're going towards a specific type of client, how you have to address the situation. So I'm not sure if I'm interpreting that wrong, but
I think, yeah, I see what you're saying. That goodwill has to do with your attitude toward all of the parties, your own client, the opposing counsel, the judge, but that priming is a way of sort of being compassionate to at least the decision maker, to not just shock them with the big issue, but to sort of ease them into it, or to give them a way to, if they're a no kind of person, give them a way to say no first. If they're a yes kind of person, give them a way to say yes. And you guys, some of you, I know for sure, a number of you work full time. And so you guys undoubtedly are familiar with this concept. You know from your supervisors who the no people are and who the yes people are. And I'm seeing lots of head shaking. You know who needs to say no, right? And you know who wants to say yes. And so I've been teaching now for almost 20 years, and I can tell you, of all the deans and associate deans that I have served under, I can tell you every single one of them, whether I need to go in with a door in the face or a foot in the door. Because there are some administrators that need to say no, but would like an easy yes if they can get one. So if you give them a no first, you're more likely to get your yes second. And then I know administrators who, they just love to say yes. So you give them the easy yes first. And then we had a colleague here. She's retired now. She's on emeritus status. Her name is Louise Harmon. And she's just a thoroughly delightful human being. And she was associate dean for several years back. And she loved to say yes. She loved to say yes. And so if you would go ask her about something, she would say, she would say the words, I want to say yes, but I don't see it yet. Can you go back and chart me the path to the yes and bring it back to me? And so if you'd go figure out, okay, what hoops we have to jump through, what blah, 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 and take it back to her, and she'd look at it, and if it was reasonable, she'd say, yeah, that works, let's do that. And so it was really a lot of fun for students, because, when she would say, somebody would go and say, I want an overload credit, I want to take this out of sequence, I want to do a semester at Georgetown, I want to do whatever, she would say to the student, I want to say yes. I need you to go back to the student handbook. I need you to chart me the path to yes. I want you to show me how this is possible. And it was great because her yeses were even easier than nos. In my experience, yours may be different. My experience is that no people do it because yes is too much work. Yes is a lot of work. And so it was great because she managed to get to the yes, and she would make the asker do the work. She would say, oh, this is going to be hard to do. So why don't you go show me how it's going to be yes, and then bring it back to me, and we'll do that. So it was great. And she was universally beloved, as you might imagine. Okay. So priming, you've got to know that audience. You got to know whether you're dealing with a no person or a yes person. And again, if you don't know the advocate, the judge that you're in front of, you got to ask people. You got to find somebody and ask. Mentorship is so important in the law for this very reason. It's not just you need mentorship so you don't get sued for malpractice, although that's certainly a worthy and necessary goal. But you also need mentorship because you need this input about audience and what they like I got from the guy in my law firm about the judge who liked the charts. Okay, so this is sort of the first strategy that you have is priming. You've got door in the face and you've got foot in the door. And so the first thing that you want to do with your document, now that we've got a specific strategy we can put our teeth into after theory of the case, of course, I guess we've got our second strategy now is priming. I want you to look at your issues, the way you have them organized in your brief, and decide whether you're happy with that. Decide whether what you have is a door in the face or a foot in the door, and whether that's what you want. And if it's not what you want, then you want to revise the organization and annotate that. And again, remember, you've got an excellent example of how to do the annotations, the sample A+ from last summer. So that's the first thing you want to look at. If you look at them and you decide that, yeah, I have a good priming structure here. I think what I did was really good. That's great. Identify the structure that you have and talk about why it works. Talk about why it is effective. So if it is effective, identify it, talk about why. If it's not effective, identify why it's not effective, what would be more effective, and how it is that you're going to reorganize to achieve that. So that's your first major strategy. So we're going to finish a couple minutes early because I didn't give you guys any kind of break. The 10-word theory of the case, due on Wednesday by 6:30 p.m., uploaded to Twin. If you got a reminder email from me about your notice of student responsibilities or the paragraph, they need to be uploaded to Twin. I know a lot of you sent them to me through email, and I'm sorry to ask you to do it this way, but it saves me a ton of time, which is time I can better use to review things this week when you submit them on Wednesday. So if you'll upload those to Twin, that would be awesome. By 5 p.m. tomorrow, because I'm going to do something with the appellate brief descriptions to give you guys on Wednesday. So if I have them by 5 p.m. tomorrow, I can put them all together and you guys can do that. Another thing for Wednesday, I am going to post immediately after we're done here, I'm going to post a motion brief. It's an actual brief. It's only very ceremonially redacted. You can still see everything through the redaction. And when I showed it to the person who gave it to me, I said, I used a black marker, I used a blue marker, I couldn't get the thing to redact. And I said, I've tried this a couple of different ways and I can't get the redaction to not show anything. And she said, it doesn't matter. It's a matter of public record. It's already out there. So I know that you can see the stuff through the marker. It doesn't matter. It's fine. So what I want you to do with the motion brief that I'm going to send you, I want you to make notes on it, sort of similar to what you did with 8.8 or what you will do with 8.8 with your appellate brief. For the appellate brief, I asked you to do exercise 8.8, where you identify the different traits within your brief. I want you to do that also with this motion brief. Identify the ethos traits, because what you'll find very quickly is this lawyer really undercuts his own ethos pretty seriously, but it's not enough to look at it and say, oh, this guy has no credibility. We want to go deeper and figure out, why does he have no credibility? What is it that he did that was ineffective? And what did he do that was effective? Because it's not all bad. So I'm going to post those, and I think that's it. Any questions? Okay. Oh, wait, Rand, sorry.
I guess I'm just a little bit confused on the 10-word theory of the case.
Yes.
We're supposed to be taking that from our actual brief and then just, okay. I just wanted to make sure I was clear on that.
It's not, I mean, you're going to draft the 10-word theory of the case for your brief.
Okay.
Yeah, it's unlikely it's in. Let me ask you something, because I'm starting to remember something from last week, and I'm getting confused because this is one of those things that I'm having both classes do, and you guys are doing them at different times. Did we look at that at the bad brief?
Yeah.
Yes.
We did look at the bad brief. Okay, great. That's great, because that means that you guys already have a heads up on that, and it's going to make that 8.8 thing that much easier. So you guys already know that it's you're going to look at the snarky one. So I want you to look at it and figure out, where did it fail on ethos? What was the problem exactly? So that we can be a little bit more deliberate about our study. So next week we'll start with exercise 7.2. We'll do 8.8 on your brief, and we'll do 8.8 on the snarky motion. Okay, fantastic. Hold on. Lorraine, you wanted me to stay? Okay. So let me get Loretta's question. Yeah.
So the 7.2 and the 2 8.8 exercises, we're not posting them anywhere. We're just going to be prepared to discuss them.
Exactly.
Okay.
Okay, so I will see you guys on Wednesday.
Bye.
Have a good night.
Thank you, you too.
Bye.
Professor, I have one question for you.
Yeah.
For the AWR, the outline,
Yes.
when do we go over that?
Whenever you want. You got to let me know when you want to.
Okay, so it's because I saw that it says should meet with professor to discuss. So I just schedule that with you separately.
Yeah, if you just want to shoot me an email. Most days I'm free pretty much all day, but easily like 10 to 4, I'm usually wide open.
Okay. All right. Thank you.
Yeah. Okay.
Hi.
Hi.
Okay, so I just have some questions because I'm not sure do you want me to get all the briefs, the briefs from the Hobby Lobby, or just the actual one that went, well, they all went, no, because they asked, all right, for the Hobby Lobby, you said to me, since it's a 20-page, I could probably focus on just a statement of the facts, correct? Am I interpreting this correctly in the email?
I don't remember specifically, but that sounds exactly like something I would have said.
Okay, so
it's a good thing to do.
I saw a couple of briefs.
Mm-hmm.
I'm not sure. Do I just take them all? Because I want to do an outline for you that I don't even know what to do, actually. So
okay. So to narrow it down, what you want to do, if you're going to focus just on the statement of facts, which is a great thing to do, you want the statement of facts from the petitioner's brief and the respondent's brief.
Oh, from both. Okay.
Yeah.
Okay.
Alternatively, I mean, if you want to compare the strategies that each use, you could do it that way. Alternatively, you could look at just the winning party's brief.
Right, that's what you were saying.
And show how that relates to what the court did.
Okay, I mean, I think that for that case specifically, I think that might be, I mean, I understand the arguments the other side used. I'm not looking at it the way we're learning in class now, but I understand the gist of it all.
Right.
And I think that might help me narrow things down more so.
Yeah, because 20 page, once you start getting into this, you're going to realize very quickly 20 pages is not going to be a lot.
Okay.
Because there's a lot. I mean, look at how much time we spent dissecting single sentences.
Yeah.
You know, I mean, there's a lot of meat in statements of facts.
Right, and I can also imagine that going in before the Supreme Court, you have to have a boatload of arguments.
Absolutely. So, yeah. So with the statement of facts, if you want to compare the winning statement of facts to what the court did as evidence of what the court found successful, and analyze those strategies. Okay. So, you know, if they said, contraception is, if the brief said contraception is immoral, and we are, it's against Christian principles, and we're a Christian nation. I don't know, I haven't read the briefs, but it's against Christian principles, and we're a Christian nation. And then in the court's decision, it said it's immoral because we're a Christian nation. Well, that means that strategy worked.
Right.
Right? So you want to put a label on that strategy. What is that strategy? And and then start to identify, and then once you've identified the similarities between the statement of facts and the factual statement that the court gave in the opinion, once you've just identified the similarities, now you want to start to group them by technique. Was there a single technique or a group of techniques that seemed to be most effective in this case? And if so, what was it, or what were they? And so you're not really going to know exactly how to organize the body until you have done those comparisons.
Okay.
Because you're not going to have enough information yet to know really what your thesis is.
Okay.
You know, so your thesis might be something like the plaintiff used the plaintiff's most successful technique was metaphor.
Okay.
So then you know that you're going to analyze a series of metaphors. But if it's something else, you might organize it a different way. So you won't be able to organize it for a while. So this conversation suffices for the outline, because you're not going to have an outline for a little while.
Right.
Because you're doing some analysis first. Does that help?
It does help me, because one of the things that I know that from reading it and just my understanding of it now, obviously I'm going to delve into it a little bit more.
Right.
But my understanding is, because they're Catholic, Hobby Lobby was a Catholic, their faith is Catholic. And they were saying that they offered the contraception for the, you know a little bit about it, right? I'm sure. Yeah, so they offered there was 4 that they had a problem with, of the contraceptive drugs that were in the health plan coverage.
Right.
And they were offering the others in part of it, but then there were 4 that they felt, I guess it was the soul, when does the soul become a being or existence?
Right.
And so they were saying how it spills over into their business, because, the structure based upon, I guess, I've learned it's the way that the government or that state says it's a religious organization. So they're playing the music in the thing, they're given to charitable contributions to charity, so on and so forth. So those, I would think that that's what helps sway the argument in some part. I'm not saying, I know you're thinking in the ethos and the metaphors. And
all right.
I'm just trying to understand how that plays into what you're looking for.
Right. So what you want to start to discover, and it's really going to sort of unfold over the course of the semester. And so you may want to read a little bit ahead, at least in the textbook, maybe not the articles, because that's a lot of reading, but you might want to read ahead in the textbook a little bit. What you're going to see is there are, like we started with ethos tonight, and like theory of the case is, it's partly an ethos strategy, it's partly a logo strategy, it's partly a pathos strategy. But there are other strategies like, an ethos strategy. One is an appeal to authority. And for that to be credible, it has to be an authority that the audience recognizes. And so you'll start to, you'll notice the similarities, and then you're going to start to get a vocabulary to attach to those similarities as we go through the semester, so that you can talk about them as strategies instead of just, this was an argument that worked. Well, what kind of argument was that? Was that a logos-based argument, an ethos, a pathos? And if it was ethos, what trait was that? What characteristic of that trait was that? So you'll start to get a vocabulary to apply to the similarities, and you'll start to notice the differences. Once you have gotten through, so you've got about a week, basically, I think, on the timeline to do, maybe a week, to do the basic comparisons, to figure out what they are, and then to sort of map out an introduction.
Okay.
So once you submit your introduction, probably what I'll do is want to touch base with you after I read that.
Okay.
And then start talking with you about, okay, what have we talked about so far in class that relates to these strategies, or let you know, okay, here's what you're identifying. We're going to talk and show you specifically here on the syllabus, this is where we're going to talk about that. So if you want to read ahead, that's where you're going to read ahead.
Okay.
Yeah. So we'll touch base again in about a week and a half.
Okay.
And yeah, I think it's going to be fun to write. I really do. I mean,
I hope so, because
it's fun to it's fun to look at the stuff and see what worked and what didn't work.
Right.
And like I said, a good persuasive strategy should be invisible. It shouldn't look like you're trying to persuade.
Right.
And so that's why I am so fascinated with this material, because to me, it is a little bit like the lawyer's magic power to be able to look at something and be able to harness it and to do it intentionally, and then to be able to recognize why something is persuasive. Because if you can recognize why it's persuasive, like you can say the emperor has no clothes if you can explain how it is that you know that.
Yeah.
And so it becomes I really think an advanced study of persuasion is a lawyer's superpower. It gives you so much more that everybody else is kind of stumbling around in the dark on. They have a general feel for it, but they don't have any vocabulary. They can't break it apart into pieces. They can't use it or manipulate it or target it. That's the hardest thing, is we sort of know when we're being persuasive, but it's harder to do it intentionally and to target it, to say, okay, this is my audience. This is what I have to work with factually. This is what I have to work with legally. Okay, what strategies do I have available to me to make that work? So by looking at this statement of facts and the court's opinion, you're really going to get a lot more insight into sort of, what happens in the box when you cut the lady in half.
And Scalia was on the bench, so I might have a good insight from him.
Yeah, I mean, he was really, he just let loose the last week. I mean, he was always pretty snarky, but he really let loose. And there's this mythos about Scalia that he's brilliant. And so I think he was manipulative, and I think he was masterfully persuasive. I don't know that I think he was brilliant. I don't know that I think he was smarter than your average bear. I don't think he was the smartest guy on the court by a long shot. But he managed to make being sort of out there, sort of the myth surrounding him was, well, clearly he's a genius because look how he behaves. And it's like, well, he could also be crazy.
Yeah.
He could also be crazy. But, we don't like, it's like I was saying about the factual theory. We don't want a system in which a Supreme Court justice can be crazy.
Right.
We don't want that. But we're okay with eccentric.
Right.
Because that's a sign of genius. So, yeah, it's really, working with his writing is really interesting.
I bet.
Yeah. So, well, you're about to find out.
Yeah. All right. Well, thank you very much.
You're welcome. I'll talk to you Wednesday.
Thank you.
Bye.